Parnell to represent Ms. Danielle Redlick, who's present in court.
All right, good morning, everyone. We're here today for sentencing. State, are you ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
I'll start with the state. And before we begin, I just want to let you all know I have reviewed the pre-sentence investigation that was filed yesterday. Did everyone see that it was filed yesterday?
Yes, Your Honor.
Yes, Your Honor.
I've also reviewed some letters that Ms. Conlon provided to the court. Mr. Wiggins, Ms. Garcia, have been able to review those letters as well?
Yes, Your Honor.
Also, I've reviewed the statute. I've also looked at and reviewed the defendant's memorandum of law regarding the sentencing. State, I did not see one in the filed on behalf of the state. Did you file one last night and I just missed it?
I did not file a memorandum. I do have there's some argument that needs to be made as to the issues raised by the defense. I just have one case for the court to consider as part of my argument.
All right. Can I have a look at that now?
Yes, Your Honor. May I approach?
Yes, sir. Ms. Conlon, Mr. Parnell, have you had an opportunity to look at the case the state provided to the court?
Yes, Your Honor.
Yes, Your Honor. I just wanted to inquire of the court. The court like to have the parties address the sort of remaining legal issues that are in play for the sentencing before we proceed to any evidence or argument as it relates specifically to the sentencing itself.
Yes, I think that would be the better way to handle that.
So, Your Honor, the state concedes the defense's argument that a finding by the jury would had to have been made in order for this court to have the discretion to impose a prison sentence or any sort of additional incarceratory sentence at the sentencing here today. So that is not an issue that is in dispute. The issue that is in dispute is the issue that defense counsel has put forth that this court does not have the discretion to impose a probationary sentence as a result of the conviction of the third-degree felony. The state has provided State v. Simmons, which is a Supreme Court case, a Florida Supreme Court case at 687 Southern 2nd 827, which I think pretty squarely addresses the defense's argument, which states under the 1994 sentencing guideline, which are the current sentencing guidelines, this court has the discretion of combining non-state sanctions such as a incarceratory sentence followed by probation without the need or requirement to justify that as any sort of departure. And so clearly under this case law, the court retains that jurisdiction. If we didn't have that case to consider and the court thought about the defense's argument, what the defense is essentially arguing is that in any situation where a defendant does not score over 22 points, a court could not sentence that defendant to a year in jail followed by a year in probation. That every defendant appearing before this court for sentencing who did not score discretionary prison could not be sentenced to simply that, a year in jail and a year in prison. And that's obviously not the case. I'm sure this court can think back to maybe hundreds of pleas and sentences that it's imposed that take that form. You would expect that if that was the state of the law, that there would be a clear case or some sort of site that defense could provide, because that would be a really, really drastic constraint on this court's discretion to sentence individuals who do not have a discretionary prison sentence by way of their score sheet. The maximum statutory sentence is defined in the statute as 5 years, and that is 775.082, sub E within that statute. The sub 10 section that's cited relates specifically to the conditions that have to be met for an upward departure in the imposition of a particular state prison sentence. And so that subsection that's cited does not modify the statutory maximum, which is the 5 years, which would mean that there is approximately 2 years and 10 months of jurisdiction for this court to impose a probationary sentence if the court saw fit to do so. The other issue that has been brought to my attention, and I think this is in part because of the pre-sentencing investigation that was prepared by the Department of Corrections, which recommended probation with conditions related to substance abuse evaluation and no alcohol. Some cases that defense provided to me that essentially suggest that the court and the conviction, the facts that underlie the conviction are such that the court couldn't impose a substance abuse evaluation and alcohol prohibition condition because there's not a nexus related to the offense. I would provide and admit for the record, if I can approach the clerk, 2 documents separately, please. been marked as states A for identification purposes, which is the affidavit of violation of probation filed in Seminole County, and then the judgment and sentence related to this defendant's admission to that violation of probation filed in Seminole County. Your Honor, this time would take, request that the court take judicial notice of both of these official court documents and admit them as exhibits. Yes, Your Honor.
So the court will take judicial notice of the amended affidavit for violation of probation in the Seminole County 2018 EF 290, along with the judgment. State's exhibit 1 and 2.
Your Honor, the state has offered those exhibits to provide additional record evidence that I think that already exists for the court to draw upon that establishes that alcohol was an issue within the facts and circumstances that led up to the commission of the offense that Ms. Redlick was convicted of. And the affidavit of violation specifically alleges that she consumed or possessed alcohol in violation of the probation that she was currently on at the time of the offense. And then ultimately, she admitted to that violation. And so the court has both what it heard in trial and this record evidence that establishes that substance abuse, the consumption of alcohol has a nexus to this particular case, and if the court found it appropriate, could impose that as a condition of probation if the court ultimately decided to go that direction. So those are my arguments. Thank you, Your Honor.
All right, thank you. Ms. Coleman?
So I'm going to address first the argument that whether or not this court can legally sentence Ms. Redlick to additional probation time. We did a sentencing memorandum, and because the way the statute reads, it says that a defendant is sentenced for an offense committed on or after July 1st, 2009, which is a third-degree felony, but not a forcible felony. This is not a forcible felony. And if the total sentence points pursuant to Florida Statute 921.0024 are 22 points or fewer, the court must sentence the offender to a non-state prison sanction. So we know that the maximum incarcerative portion of that statute is talking 364 days, which would be the max, because 366 would then be prison time. And so we know what the incarcerative maximum penalty is. Under the Fontaine case that was mentioned in the sentencing memorandum, you have a circumstance here where the legislature has changed the maximum penalty for someone who scores 22 points or below, and that is where Ms. Redlick falls. Under the Brown case, they reference how this is now the statutory maximum. And because of that, what we see is the statutory incarcerative max, and under the Fontaine case, because the wording of that statute doesn't give a maximum for the probation part, we're saying that under Fontaine, it should just be that 1 year.
And so essentially, that completely changes the total term of a sentence to just that 1 year, the 364 days?
Yes, and the reason why we're saying that is because in Fontaine, what they did is they looked at the reckless driving statute. And the reckless driving statute has a max 90 days incarcerative sentence, but it does not have a max probationary sentence. And because of that, the court stated, this court has held that a term of probation is not to exceed the statutory maximum for incarceration. And so therefore, the probationary term could not have exceeded 90 days.
Can I stop you right there and ask a question? Yes. If the reckless driving statute doesn't have a term designated specifically for probation, isn't that different from the charge your client was found guilty of? Because there, 5 years probation is the maximum. How then does Fontaine Square, or how is it, to me, it seems as if it's distinguishable from the case that I have. How is it similar? How is it fitting your case?
Okay, so the reason why it's similar to Fontaine is because normally all of the F3s would be 5 years prison, 5 years probation. What's happening with the 22 points or less, the statute, is that it was five years. Now we are in a separate category. And in that separate category, the legislature has only explicitly stated what the maximum incarcerative portion is, just like the Fontaine case. So because they're taking it out of what it was and created a new statutory maximum with only the prison or 365 maximum, but because they did not explicitly state the probationary period, it's just like Fontaine.
Because for a reckless driving, it's not specifically stated, correct?
Correct.
But when it is specifically stated, I still have to use the Fontaine case? Is that what you're saying?
I'm saying that only if that person falls under the 22 points or less category. That's our position on that issue.
Anything else you want?
Yes, so the state also talked about PSI. I wanted to go into the recommendations of the PSI and whether or not this court has the ability to impose alcohol-related conditions if this court were to give probation, and as well as the other things. But I saw the court look at the state, so I don't know if you wanted to address that first.
No, he looked as if he was about to get up, so I was going to see if he had something to add, but no, I'll stay with you, Ms. Conley.
Okay, so the pre-sentence investigation report, which we received yesterday afternoon, they request mental health evaluation, drug and alcohol evaluation, and any recommended treatment, and anger management classes. These recommendations are not relevant. They are improper because it's not reasonably related to the circumstances of the offense as required by Florida Statute 948.039. I provided the court and the state with Gomez-Rodriguez versus State, which is 632 Southern 2nd, 709. This was a purchase of cocaine case, and the defendant was placed on probation for 4 years with special conditions, and one condition required the defendant to not consume alcoholic beverages. And because there was no evidence in the record the offense was alcohol-related, the condition was invalid. So in this case, we have no evidence of any drug use in this case. We have no evidence of alcohol use by Ms. Redlick. In fact, Dr. Vanderveen testified that her medical records blood alcohol level was consistent with someone who had not had any alcohol. If you take a look at the VOP affidavit that the state provided, which they're using as a basis to ask the court for alcohol, I'm assuming treatment or whatnot, violation of special condition of the order of probation, and the allegation is that she violated probation by using or possessing intoxicant, which is ethanol, unless prescribed by a physician, and as grounds for belief that the offender violated her probation, Officer Leonard Jaboyne states that on or about Saturday, January 12th, presence of ethanol was detected from the offender's blood sample as reported in the laboratory report submitted by Detective Pamela Ware of the Winter Park Police Department, and the offender was in possession of vodka bottles as reported by Detective Pamela Ware on January 17, 2019. So we have the basis for this violation of probation, or one of the bases, is a lab report which we know at trial, Dr. Vanderveen testified that that her alcohol level was consistent with someone who had not consumed alcohol. So that should not be a basis for the court to impose it or to show that she has an alcohol issue. The second issue are the vodka bottles. I think it's very clear that at trial, the vodka bottles was purchased and consumed by Mr. Redlick. and the vodka bottles that were found on January 17th were found in the trash. So these were items that were linked to Mr. Redlick. So those were the reasons why we don't think that alcohol, if the court is considering probation, alcohol conditions should not be imposed. I also provided the court with Sparber v. State, and this relates to the mental health evaluation and anger management classes. In this case, the court imposed on the defendant that he not consume alcohol and required him to undergo an evaluation and treatment for drug use and mental health issues. And during the proceedings, the defendant argued it was illegal because it was not related to the charges. He argued that his competency nor mental health was an issue in the case, and the court remanded the case to the trial court to either attach records that conclusively refuted his claims or re-sentence him without the drug offender and mental health conditions. I think it's very clear that Ms. Redlick's competency nor her mental health was an issue in this case. Thank you.
Thank you very much. Mr. Whitney?
Yes, Your Honor, I would just note to the court that Fontaine is dealing with a very specific statute. We're dealing, first of all, with a misdemeanor statute, and we're dealing with a misdemeanor statute that isn't defined as a M1 or M2. It's kind of a very unique situation where reckless driving is not a second-degree misdemeanor, it's not a first-degree misdemeanor. It exists in this sort of liminal space. And all that the legislature provided was you can get 90 days. And the court, when dealing with this particular issue as it relates to a misdemeanor, said, well, then that also confines your probationary sentence, because we have no other guidance about what category this fits into. How that misdemeanor statute is interpreted is not at all instructive or enlightening as how the court is allowed to exercise its discretion when sentencing for a felony offense and imposing non-state sanctions to an offender who is not eligible to be sentenced to a prison sentence. And if you just focus on the language of 775.08-10, it expressly gives you the discretion to, or it instructs you that you must sentence the offender to a non-state prison sanction. Well, a non-state prison sanction is a term of incarceration in the county jail followed by a term of probation. Those are two non-state sentences, and the court now has a case in Simmons that shows you that there is no requirement that you provide written findings, because that's not considered a departure in any way, shape, or form. So as to that. And I would just note that the time to contest the violation of her probation, where it was alleged that she used or possessed alcohol, was before she admitted to it. And that time has come and gone.
Thank you both very much. I don't agree that Fontaine limits the court or that it applies in this particular instance such that the maximum sentence the court is limited to is only 1 year. A non-state prison sanction or non-state sanction in this case is definitely appropriate. Anything else that I need to take up with regard to legal issues involving Ms. Redlick's sentencing?
None from the state, Your Honor.
Not as far as the legal issues.
I'm sorry?
No, Your Honor.
Okay. I just didn't hear you. I wasn't hearing what you were saying. I just couldn't hear what you said. All right. Let's then begin with the PSI first. Let me start with that. Both parties have been able to review that. Are there any objections or corrections that need to be made from the state?
No, Your Honor.
Yes, Your Honor.
Yes, ma'am.
On page 1, under description, they got the name wrong. They misspelled Ms. Redlick's name. Number 2, we reiterate that their recommendations are not legally relevant based on the grounds that have been previously stated. Number 3, as the court can recall, we were ready to go with sentence, or we actually waived PSI when the verdict came in, when this case was set for sentencing, and this was not something that we thought was needed.
Anything else?
No, Your Honor.
So as far as her true name, it should be Danielle, D-A-N-I-E-L-L-E, instead of Daniela. The second one involved the recommendation, or the recommended disposition on page number 7. And the third is your statement with regard to waiving the PSI. All right, Mr. Wiggins, are there any witnesses, or is there any testimony that you wish to present to the court? Consideration.
Yes, Your Honor. Attorney Cheney Mason is here on behalf of Jaden and Sawyer and has a statement that he's going to read for them as their attorney.
Mr. Mason, you can come forward and read the statement.
I think it would be easier for me to sit there if I can.
Okay, that's fine. All right, you may begin.
Your Honor, it's hard to be old and can't see and can't hear either, but it's, as you are aware, I was appointed by the court to act as a guardian ad litem for the children in this case, some 3 years ago. And I have an impact statement that has been written by the daughter, who's now 17 years of age. They've asked me to read this in accordance with the statute, and with that I will. I'm quoting verbatim from the writing. I want to start this off by saying the only reason I am not personally reading this statement to you all myself is because I simply do not ever want to be in a room with Danielle Drohan ever again. I feel as though there has been absolutely no justice served for my father or his family, including myself and my younger brother. It takes a lot for me to talk about these things and be so vulnerable in front of total strangers. So I please just ask that you all listen to me and please take my feelings into consideration. Since I was about 7 years old, I have endured insane amounts of trauma. This trauma all stems from the same thing, Danielle Drohan. And yes, I'm referring to her as her first name and maiden name because I feel as though she should not even have the privilege of having the same last name as me or my father. I refuse to call her mother because she was never a decent mother figure to me. There were a great deal of things I was not permitted to say in court when I was testifying, which I feel is absolutely insane. I still am unable to even scratch the mere surface of the trauma I am referring to. All I want is justice for my father. It breaks my heart into a million pieces over and over to hear people side with such an abusive, horrible person and then continue to bash on a dead man who isn't here to defend himself. Sure, my dad was no angel and definitely had faults, but he was the kindest, most caring person, and I'm sure the other people who had the chance to know him would vouch for that. He was so kind, gentle, and he never laid a hand on a single person in my family, not myself, Sawyer, or Danielle. I don't even remember him spanking me. My dad always advocated for love and acceptance. He loved everyone and treated everyone the way he wanted to be treated. He was a great man with great values and loved his family. He would never hit a woman. He took my brother and I to so many different ball games, always took me out on our father-daughter days, and he was always in a good mood. Him and I used to watch Saturday Night Live together every Saturday for 5 years straight. He took me and Sawyer to the movies all the time and made sure we were always happy, fed, and well taken care of. He always stood up for others. He always wanted to joke around and play whatever game or talk about literally anything. He loved to talk, people watch, and get to know people. He loved others, and everyone loved him. He was not a bad person. I am so angry about the way he has been portrayed, so extremely angry. He was the best dad I ever could have asked for. I remember at certain points, I would imagine Sawyer and I staying with him full time if my parents were to divorce. I have no regret in saying that, and I mean it wholeheartedly. It absolutely breaks my heart into a million pieces that Sawyer has to grow up without him. I do too, but Sawyer no longer has the amazing dad to show him how to grow up and be just like him. We are both extremely heartbroken to have our pops ripped from our world so suddenly and to have been lied to about it for so long after. We miss our pops so much. I would do anything to bring him back. Someone took him from our world and ruined our childhoods, let alone the start of our lives and futures. We have endured so much since he was taken from us that it has been difficult to process a natural grieving process. We have suffered such incredible amounts of trauma to the point where our bodies have reacted to it. I have had nightmares for the past 3 years about Danielle, and more specifically about certain decisions she has made. Sawyer has nightmares too. I have developed a near fear of being murdered. I have had phases of extreme paranoia, and I've gone through phases where I've been so depressed over the situation that I was unable to take care of myself for a long time. I've lost a great amount of weight, and for a while, I would get extremely triggered and break down over someone even saying the words dad or parent. I've had an entire school gossip about me and my situation, as most of Winter Park. People recognize my last name and often already know about this so-called news story that is my life. I lost everything at once, and it was broadcasted to the world, and I have always given the short end of the stick. I am just now getting to be okay again, but this reopened so many wounds that I genuinely thought could start to heal from. You may all be fooled by the incredible mask this woman presents to you all, but I am not. My father did not get away in time. I am not worried. I am so worried for my brother. Judge, please make some kind of stipulation that Danielle not be allowed near myself and Sawyer, so we don't have to be re-traumatized like we have been already. We're both settled into our new life without our dad, and we want to be left in peace. It took us a while to get here, and we deserve that at the very least.
Mr. Wiggin?
State has no further evidence, Your Honor.
Ms. Conlon, do you have any witnesses you wish to call on behalf of the client?
No, Your Honor.
So is there any further argument for either side?
As it relates to state's recommendation or other issues?
State's recommendation.
Yes, Your Honor. The court has found that it does have discretion to impose a probationary sentence, and the state of Florida believes that that would be warranted in this case, specifically because, and I won't rehash the facts and circumstances that led to the conviction, but as the court is aware, this defendant was on probation at the time that she committed this offense. And it also is established through the record evidence that alcohol was involved in a contributing factor to the circumstances and facts of the conviction. I believe that the conduct that she was on probation for, the facts and circumstances of the crime with which she was committed, should counsel this court to see it prudent to place this defendant on a period of supervision, which includes conditions related to mental health evaluation and treatment, substance abuse evaluation and treatment, and a no alcohol condition. You have also heard the request of Jaden and on behalf of her brother Sawyer for additional condition of probation. I believe that that is warranted and justified in this case.
Ms. Conlon?
This is a first-time felony conviction. Ms. Redlick is already going to have a difficult time finding a place to live and finding employment, and it has greatly affected her already because of this. I would like to point out that the tampering with evidence is not a victim crime. Marcy's law and its implications do not apply in this case. I would also like to address something that was stated in the letter, and I have case law. Well, one of the requests that was stated by Jaden Redlick is that she is asking the court to impose as a special condition of probation that Ms. Redlick not have contact with Jaden or Sawyer Redlick. And in regards to that, I would like to present the court with Spano v. State, which is 60 Southern 3rd, 1108, 4th DCA case 2011. May I approach?
Yes, ma'am. I don't intend on no contact provision condition.
In light of that, then I will not need to discuss the case law on that issue. The state said that alcohol was a contributing factor in this case, and that is not an accurate statement of what was presented at trial. What was presented at trial was that Mr. Redlick was the one who was drinking that night. And as far as what this offense was, you had medical record, you had a doctor who testified that her alcohol level was consistent with someone who had consumed no alcohol. So imposing alcohol conditions would not be appropriate. I also wanted to address some of the things that were stated by Jaden Redlick in our memorandum of law on page 4. I discussed some improper considerations.
Hold on just a second. Okay, I'm there.
All right, page 4, it's, page 4, subsection 4, improper considerations. And one of the improper considerations would be acquitted conduct. And I bring that up because it says conduct for which a person has been acquitted cannot be a basis for departure from the guidelines. And I think what the letter has stated, it was really focused on acquitted conduct and the impact of what that acquitted conduct had on Jaden Redlick. So I would ask that the court not consider that since she was acquitted and she should not be punished for something that she's been acquitted of. Now, the reason why we don't think that Ms. Redlick should get any additional sanctions, including probation. First of all, the ultimate goal of the justice system is punishment. Ms. Redlick has spent 3 years and 4 months in jail. That is at least, she's 2.5 times more than what the legislature intended for someone in her position because she scores less than 22 points. When we're asking for time served, what that means is, it came at a price and it came at a cost to her. And this cost was that she missed 3 Christmases, she missed her kids' birthdays, she missed their school activities, she missed being around them. So that is the cost of what 3 years and 4 months did. Now, the secondary goals of the justice system are rehabilitation and deterrence. So while she was in jail for those 1,300 days, you can see that she has managed to grow as a person. It is shown by the letters that were provided to the court. We have Yvette Gonzalez, the senior chaplain, who said in her letter that Ms. Redlick participated in the faith-based program, which addresses issues such as anger management, conflict resolution, codependency, unhealthy relationships, thinking errors, as well as several religious courses. As part of this program, Ms. Redlick regularly meets with specialized professionals, counselors on a weekly basis, as well as with chaplains, expanding the network of support that she already has. We are very glad that she has taken advantage of the opportunity presented to her by our program. An evaluation of her performance places her well above meeting her goals, as she has gone from being a disciple to actually teaching others. We are confident that Ms. Redlick will be an asset to whatever community she becomes a part of. You have a letter from Laura Cassidy. She's a volunteer at the Orange County Jail and a part of the Orange County Jail's ministry. And she writes, I believe that our faith-based program has helped her, Danielle Redlick, to put her life and her choices into perspective. What I clearly know is that Danielle is not the same person today as she was in January 2019. She has been humbled in her 3.5 years in jail. She has dreams of helping other women and ministering to the less fortunate. She hopes to take her hard-earned life lessons to women in need. During our weekly sessions, Danielle would reflect on her past and speak about how she has changed and grown. She has lost precious years of her life and has mourned her past behavior and choices. She has vowed to me and to God that she will never return to that lost person she was. Her head and her heart are aligned with her strong faith, something that has been missing in her previous life. I believe that Danielle has already paid a steep price and that she is eager and ready to begin a new life as a reformed woman. We have a letter from Carol Drohan, who is Ms. Redlick's aunt. She says, finally, I see Danielle continuing in this way, and I have no doubt whatsoever that she would be an asset to society. She is the type of person who learns from her mistakes and will be extraordinarily helpful to others for what I'm seeing and hearing from her with regard to sentiment and future aspirations. I look forward to seeing what she does and hope that you will strongly consider a time-served sentence, as this will certainly aid her path in accomplishing good things with the wisdoms and faith she has accrued in all of this, as well as restoration with her children. We have another letter from Dr. Evora Baker, who has known Danielle Redlick since 1988 when they started high school together. She writes, as spiritual sisters, we kept each other uplifted and share knowledge about the ways God uses us to positively affect the lives of others. Ms. Redlick shared her experiences as a mom or mentor to several of the young women who are also incarcerated. It is her love for humanity and desire to help others make positive changes in their lives that I admire most about Ms. Redlick. I am confident that she will do all that she can to work in a position that will allow her to help others as they attempt to overcome challenges in their lives. We have a letter from Diane Smith. I have known Danielle Redlick for over a year in the capacity as a teacher and counselor. She attended my weekly classes in the Christian dorm in the Female Detention Center, Orange County Corrections, Orlando, Florida. We also met frequently for individual counseling sessions. I must say that from our first meeting, she impressed me as a well-balanced and intelligent person. She was understandably immersed in her personal and legal complications. As she grew spiritually, she began to share her faith and hope. She emerged as a leader, respected and sought out by her fellow peers. She was caring and effective as she befriended those in need. In closing, I found Danielle to be responsible and motivated with a strong resolve to help others. And you have Cheryl Cable, who is a volunteer at the Orange County Jail, who says, a few years ago, I met Danielle in the faith-based program H dorm and later the B dorm where I was teaching. Danielle was quiet yet very focused, always there for the class and ready to learn. During the years that she was at the Orange County Jail, I saw her help many women. She never spoke about what she was going through, but had a genuine concern for others in the dorm. She was there for them. Amazing. I am thankful I met Danielle. Thank you for your time. As the court can see, during this time that she was awaiting trial for those 3 years and 4 months, she has used that to grow, and she has impacted people. Now, the unique circumstances, the final goal of the justice system is deterrence. Now, the unique circumstances of this crime are not likely to be repeated. It was done at a time where there was a traumatic event, and it was in reaction to that traumatic event. It's not like it's a crime where the court should impose probation along with some kind of treatment, because you're trying to make sure that treatment doesn't cause that offender to repeat the crime, such as, for example, if someone had a drug addiction and they stole items, you would want to treat that addiction so that they would be deterred from committing that same crime in the future. Here, you don't have that. You don't have, addiction or mental health issues. This was a traumatic event that happened, and for those reasons, we don't believe that this is something that is likely to repeat again. We would ask the court for time served in light of the fact that she has already served more jail time than a normal defendant would on a first-time felony.
Ms. Redlick, is there anything you wish to say to the court?
No, Your Honor.
Come to the podium.
You said this from the time.
And you stated you did not wish to make a statement, correct?
No, Your Honor.
Ms. Redlick, you testified at trial that you killed your husband, and the jury has found you not guilty of that conduct, and I will not sentence you based upon that conduct. You further testified that after you killed him, you were scared and didn't know what to do, and you froze, and the evidence shows that there were over 10 hours where you waited before you called 911 and gave varying stories as to the cause of Mr. Redlick's death. But you stand before me today for your conduct during the time between Mr. Redlick's passing and the 911 call made on the next day. And it is that conduct for which you are going to be sentenced today. According to the crime scene pictures and evidence, bloodstains were smeared throughout the home. You used bleach and other cleaners to clean what looked like a horror scene. Crime scene photographs also showed where you left the cleanup towels and a bucket of colored water. The blood pattern expert testified that typically blood patterns could tell a story or explain the circumstances surrounding a homicide crime scene like this, but not so in your case. The expert also testified that as a result of your conduct, it was virtually impossible to determine the exact circumstances surrounding Michael Redlick's death. The scene was tampered with so much so that the blood evidence was of little to no value to determine what happened between the night of January 11th of 2019, and mid-morning, January 12th of 2019. Conduct for which the jury convicted you, tampering with physical evidence, deserves more prison time than you have served. But the law does not allow me to do that, and I will not sentence you to a prison sentence. You have already been adjudicated guilty of count 2, tampering with physical evidence. And so for that conduct, I will sentence you to 364 days in the Orange County Jail with credit for 364 days time served. That's going to be followed by a period of 12 months of probation. You will report to probation by 3 p.m. The office is on the 7th floor beside courtroom 7B. Within the first 30 days, you will sign up for and you will submit to a mental health evaluation and complete the evaluation and any required treatment within 12 months. I will impose court costs, and there is also a public defender lien that should be imposed.
Court costs of $418.
Mr. Parnell and Ms. Conlon, for the public defender lien, what do you feel is an appropriate cost for your services for the trial and the litigation?
Judge, she's been in jail for 3.5 years on this. She needs to spend her time and resources on rebuilding her life and her family. So we'll be asking for the default standard fee of $100 for the public defender lien.
I'll impose a $300 public defender lien for the services that were imposed or that were provided. And as I stated earlier, there are court costs. The clerk will tell you what the total is.
Court costs of $418, state fee of $100, public defender fee of $300, their fee of $50, or a total of $868.
For the $868, you're going to report to the collections court program and set up a payment plan to make those payments. You have 30 days to file a written notice of appeal, or you waive that right. And if you need an attorney to help you with the appeal, let me know, and I will appoint one to represent you.
I don't want to interrupt the court, so.
You want to say cost investigation?
No, Your Honor, I wanted to address another matter, but I was trying to not stand in the middle of the court's.
Do you have any questions about your sentence or your appellate? I do not, Your Honor. Anything further I can take it from the state?
Yes, Your Honor, I believe that the sentencing order needs to accurately reflect the time served. So it should be however many days with that many days credit.
It says 1,228 days.
So she's sentenced to 364 days with credit for 1,228 days.
I believe that the proper sentence should be she's sentenced to the number of days she served with the credit for that time served. Defense can correct me, but I think that's how the appellate court would expect that's the phrasing of that sentence, especially when probation is following and we have more credit than we have sentence. I think that it should be the proper way to phrase it is she's sentenced for 128.28 and she has 128.28 credit. That's a lawful sentence.
Mr. Parnell?
Judge, we agree with that. We want to make sure that in the event that this is argued about in the future, it is abundantly clear that nobody's trying to take away Ms. Redlick's credit, which I understand the court's not trying to do that.
No, I'm
And
not.
she is in no way affirmatively waiving any credit that she has in the event that there is some sort of violation.
So the sentence would be, my concern is I don't want her to be sentenced to a sentence greater than the 364 days.
You do not have the discretion to impose a non-state prison sanction at the time of sentencing. So you are not, by sentencing her to what she's already served, imposing a non-state prison sentence. So we can't, I think it has to accurately state that she was sentenced to that number of days and she has credit for that number of days. I believe that's the form that the sentencing order should take to accurately conform to.
And see,
This is just my recommendation.
I disagree, because the sentence can't be more than a year. I cannot sentence her to a term greater than 365 days, even though I'm going to give her credit for the time that she's already served. Because
And that's why you're.
in that case, then she is receiving a prison sentence, even though she's already served the 1,228 days. The sentence is what I'm pronouncing.
I've given my recommendation. I respect the court's reading, and it may be a bit academic at this point, but that's just my recommendation, what I believe the form it should take. But I will sit down and allow the court to.
Ms. Conlon, you have something you wanted to say? That's how the sentence will be imposed. She's being sentenced to 364 days. She has already served 1,228 days incarceration. Anything else I need to take up, Mr. Wiggins? Ms. Garcia?
No, Your Honor.
Ms. Conlon? Mr. Parnell?
In the event that she does seek to relocate while she is serving the probation sentence, does the court have any objection at this time to her transferring probation either out of county or out of state if ultimately that's the decision she makes?
Out of state, it would require an additional $100 fee.
And the administration that comes from her endorsement, I'm just asking if the court has any, I guess, stance on that at this time. Because I think we would have to come back to you later on, and so we just want to get that.
As far as it relates to transferring probation out of county, the court has no objection to doing that. Still, they'll need to report. For probation transfer out of state, that's going to be an additional $100 for an administrative fee for that. So if you do decide, then that's an additional. John, I have a question. If she decides not to, if she does decide to travel, or not travel, but transfer to another state, when is that $100 going to be payable, or do I need to impose it today?
It's due immediately when she makes the request. We can't really collect it if she doesn't have a plan right now, but as soon as she makes the request, the payment is due. You can't even submit it.
And so she just pay that through the.
Yeah, she'll pay that through Department of Corrections.
Oh, she'll pay it through DOC.
Yes.
Okay. Do you know for certain right now whether your plans are leaning more toward leaving the state? Probably not, Your Honor. Probably not, okay. Well, then let me do it like this. I have no objection to you transferring your probation out of state. The $100 would be due. And obviously, I have no issue with you transferring your probation within state to another county. But do understand that one more question. Sure. Can I impose it, and if she never decides within those 12 months to go, that's just something she doesn't have to pay?
I don't think you need to order it on probation orders. It's an administrative fee that the department charges. It's kind of outside of what the court.
So I don't have to deal with
I
that.
think you have to.
I just have to announce it or let them know.
Yeah, we have to announce to make her aware of it. If she wants to do it, she has to kind of, you don't have to.
So there. You just know now that you would have to pay that money if you do decide to travel out or transfer out of state. Anything else?
That's all for right now, Mayor. Thank you.
Were we also hearing the motion for return of property?
That's already scheduled and docketed for, I think, September, or someday in September, which would run after the appellate process. And so we already have a court date for there. I think it will take a little bit of time to get organized and everything, so
Okay.
I'm not prepared to do that right this time.
All right.
If we need to bump it up, we can certainly ask the court to do that. From the date.
The day that it's done, I have a 3-week trial period beginning the 8th.
I think
No, beginning the 15th.
16. I believe the 16th, Judge.
Okay. So
Not sure what
there would be some time during the hearing period to bump it up, but I wouldn't be able to hear it this month. Okay. All right. Anything further I can take it from the state?
No, Your Honor.
Defense?